Another in our series of topics of lessons learned from the experiences under the Bush administration. Today we're delighted to have Neil Kinkopf with us from Georgia State to talk about executive authority, executive power. When the program in public law was getting started under Professor Powell's able leadership, one thing Jeff had the good sense to do was to ask Neil to be the first public law fellow here at the law school, and Neil was instrumental in getting the program up off of the ground, and we're always grateful for him for the valuable service he did while he was here with us. He's good friends with many people on the faculty, and it's great to have him back here today. He's had experience both inside of government and outside on matters of executive power, having worked in the Office of Legal Counsel during the Clinton administration, whereas most of you know, one of the major items on the agenda of that office is to advise the president on the separation of powers, executive authority, and other constitutional questions. And since he left government and went into academia, he's become one of the leading scholars on several important topics, specific topics under this general heading, as well as executive powers more generally. He is one of the academics who took the early lead in analyzing the Bush administration's use of signing statements and has spoken widely on that topic as well as others. So today we've asked him to provide a broader gauge overview of the subject and what perhaps a President Obama might learn from the experiences under the Bush administration. So would you join me in welcoming him to our podium this afternoon?
Thank you, Chris, and thank you for this opportunity to return to the Duke Law School. It feels like coming home. There's so many good friends on the faculty here, and I'm eager to engage with the students here in the room. You know how fortunate you are to have this faculty to learn from. Let's see, in thinking about the lessons learned during the Bush administration on executive power, I think the first lesson we've learned is that this is a really important topic, right? That our conception of presidential power matters, and that separation of powers law and the law of presidential power matter, right? And that's different than when I was in law school, right? And when I started practicing. In those days, sort of the glamour topics were individual rights, right? Equal protection, privacy, speech, religion. Those were the big ticket issues. And while those remain areas of significant controversy, right, executive power questions have really come to the fore. There's a real sort of, I think, public awareness of this as well, right? The cover story in the New York Times Magazine last Sunday was all about presidential power, right? So I want to thank George Bush. He's made me cool and popular, right? This has been great. I never thought that could be done, right? But he managed to make that happen. Or not so much me, but what I do anyway. And so that's almost as good, right? And so in thinking about presidential power, about executive power, I was fortunate to begin my career at the Office of Legal Counsel. Right? It was my first real lawyering job after a clerkship. And the office was headed by Walter Dellinger. Chris Schrader and Jeff Powell were deputies. Stuart Benjamin was a colleague. And I was able to learn from all of them. Right? And so if that sounds like sort of the best law job you can imagine, it was. In fact, it was even better than you could imagine it being. One of the issues we grappled with, though, throughout our time there was, what was the right conception of presidential power? Right? And there really, I think, are two competing conceptions. One is sort of unilateral and confrontational use of presidential power, conception of presidential power. The other is a more sort of accommodationist and cooperative model of presidential power, or the allocation of power between the president and the other branches of the federal government, right? And this brings me to, if you read the the couple sentences I wrote for this talk to Machiavelli. I used to always wonder about this in Machiavellian terms, right? Machiavelli, when he wrote The Prince, famously asked whether it is better to be loved or feared, right? And when he asked this question, when he wrote this masterwork, it was so provocative that it wasn't published in his lifetime, right? He waited till after he was dead for it to get published. It's hard to imagine today a work of political science really being quite so subversive or dangerous, right? That if we went back 500 years ago, or if Al Gore went back 500 years ago and invented the internet, it's the kind of thing that snippets, you'd all be sitting out there furtively searching the internet looking for snippets from it, and maybe some of you are as I look around the room, or we'd be getting spam emails saying that we could buy bootlegged copies of The Prince, spelled with an S instead of a C, so it'd get through our filters. Machiavelli asked this question, is it better for the prince to be loved or feared? Right? And I think to sort of translate that into modern times, it sort of translates to what model, to our times, to our polity, what's the better model of presidential power? Is it sort of, I will equate with the fear model, unilateral and confrontational, right? That model of power, or to be loved, right? The accommodationist, the cooperative model of federal power, okay? Well, Machiavelli's answer to that question was that it is better to be feared than loved, right? Actually, he said, it's better to be both, right? But that's not realistic. You can't be both. And so when you have to choose, better to choose being feared than loved, right? And sort of in just sort of general discourse around Washington, around the Justice Department, in the halls of Congress and executive agencies, I think people equated, in fact, they would in their speech patterns, they would equate the unilateral confrontational model with the pro-presidential view of the Constitution and the more accommodationist cooperative model with the pro-Congress view. And I was never sure that that was really right? I mean, that's a view that says Machiavelli was correct, that it's better to be feared than loved, okay? That's the pro-presidential view. I was never exactly sure. I thought maybe there was something to be said for accommodation, even from the perspective of the president. And that's really the question I want to examine here today. Okay, but before that, I want to talk a little bit about the Bush administration, right, and what it has done, okay? I think it's pretty clear the Bush administration has chosen the feared model, right? The unilateral confrontational model. And I'll just throw off a few randomly chosen examples. There are legions of them, but just a few, right? First, what to do with detainees in the war on terror, right? What kind of procedure to have to determine whether someone is in fact an enemy combatant and what to do with them. The Bush administration followed its own view of what to do with that, right? Deliberated amongst itself, right? Not publicly, not with Congress, didn't go to Congress to get a law. It just decided how enemy combatants would be treated and in fact asserted that it was the president's prerogative alone, impervious to the review of both Congress and the courts. Now, eventually, Congress in 2006 passes the Military Commissions Act, which gives the president basically everything he ever wanted anyway, right? So that you might think of the president's assertion of power as a useless exercise. He didn't need to. He could have been accommodationist and got what he wanted. Although I think strategically, right, the president followed the unilateral model not simply to establish the kinds of military commissions he wanted, but to establish the fact that he has that kind of power, that he doesn't have to consult with Congress. Okay, similarly, the warrantless surveillance program, or the terrorist surveillance program as it's also known, which eventually Congress largely capitulated to in legislation, initially was adopted completely in secret. Its existence eventually was leaked. It led to a lot of controversy. Congress yelled and screamed and then basically blessed what the president was up to. Not exactly, but close. In 2006, right, we have a midterm election in which I think the public can be understood to have repudiated the president's position on the war in Iraq. Supplement that with the report of the Iraq Study Group, which was issued at around the same time, saying we need to take a different course, scale back. What does the president do in response to all of this repudiation? The surge. Right? Now, whether it's working, not working, that's beside the point for my purposes. Right? For my purposes, what's important is the president decided, I'm the decider. Right? I make these decisions. I have my own view, and the rest of you, well, like it or lump it. This is how it's going. Okay? More on the domestic side, right? Think of very recently the initial bailout plan that the administration submitted to Congress. Now, they did submit it to Congress, right? So that's good, right? But what was the plan? The plan was give me $700 billion to fix the economy and go away, right? That was the plan. A very unilateral approach to the economic crisis. Congress's response, well, we'll get to that in a little bit. The politicization of the Justice Department, right? Using the Justice Department, the president uses the Justice Department to pursue sort of partisan and political ends in a whole host of different ways that have come out in a number of different reports recently. One of the most sort of public of the controversies is the controversy over U.S. attorney firings, and I think in that controversy what's telling is the president's or the White House's defense, which is to say Congress has no business inquiring into this matter because the removal power is exclusively the president's. Congress has no part of the removal power, and so has no business looking into how or why the president came to remove the U.S. attorneys that he removed, a unilateral confrontational view of presidential power. And then lastly, signing statements. Right, which if you take a look at all of them, and the number right now is up by my count to 1,069, and if you look at all of them sort of together, what they demonstrate is a contempt for the idea that Congress through law may bind the president, may tell the president what to do, that the president unilaterally will decide what he's going to do, what's in the best interests of the nation, and what course to pursue. Okay? Now, sort of as a legal defense of this approach, I think the best and most notorious example is the torture memo. Right? The torture memo dealt with whether or not the president could order the use of torture to interrogate enemy combatants. Okay? There is something called the Convention Against Torture, which says no torture, right, as the name would indicate. We also have an anti-torture statute, which says, as its name would indicate, right, no U.S. personnel may engage in torture, right, outside the United States, says the statute, because presumably inside the United States is taken care of by other statutes, okay? So international law treaty says no torture. Domestic law statute implementing the treaty says no torture. The Justice Department issues a memorandum saying that either the statute prohibiting the use of torture doesn't apply, even though it clearly does, or if it does apply, as it clearly does, it's unconstitutional because Congress can't tell the president what interrogation techniques to use in the war on terror. Right? Congress has no authority in this area, says the Justice Department, and it cites, recognizes, discusses no congressional authority. Even though, if you take a look at the Constitution, it specifically grants Congress the power to define offenses against the laws of nation, define and punish offenses against the laws of nations, right, which is what the anti-torture statute aims to do. It gives Congress the authority to make rules for the regulation and government of the military, right, and to provide for captures on land and at sea. Okay, all of these powers appear to be at least relevant to, right, citable sources of authority for Congress, but the Justice Department is so contemptuous of the idea that Congress would have any authority that it doesn't even recognize them. Right? The view expressed in the torture memo is, I think, fundamentally incompatible with our constitutional system, right? Because these decisions, right, decisions of that sort, whether we're going to torture people, are the kinds of decisions that define us as a nation. And they're the kinds of decisions that ought to come from a process of deliberation, right, and approval through the constitutional process of bicameralism and presentment. They're not the kinds of decisions to be made alone and in secret by the president, right? It's fundamentally an affront to the system of checks and balances, right? To democratic accountability and to Republican notions of deliberation. Okay? Now, the torture memo is not an aberration. Right? And I think there are two pieces of evidence that would demonstrate that it's not an aberration. First of all, after it was finally leaked, the administration repudiated it. Actually, it didn't repudiate it. It withdrew it. And in the section dealing with the president's power, what the withdrawing memo said is that the president has said we will not engage in torture, and so the whole discussion of torture was dictum. Right? Not that it was wrong, it was dictum. Why not say it was wrong? Well, we know at least one other program that relied on that way of thinking about presidential power, and that's the warrantless wiretapping program. Right? Also, if you take a look at the 1,000+ signing statements that the president has issued, right, it's impossible not to get the sense that that's what's driving all of those signing statements as well, that vision of the law, that vision of the president and the president's power. Okay? So the Bush administration seems to have clearly chosen fear over love, right? Confrontation over cooperation. Okay? But this story has a happy ending, right? The Bush view is repudiated. The correct approach of accommodation is credited. Where? Well, first in the court, right? Our first hero is the court, which rejects unilateralism in a series of opinions starting with Hamdi versus Rumsfeld, then Rasool versus Bush, Hamdan, right, and most recently in the Boumediene case where it stands up for individual rights and habeas corpus. Right? Moreover, the public gets it. Right? The public gets it and rejects the Bush view by electing Barack Obama to replace him. Oprah Winfrey comes bounding onto the set of her show and declares hope has won over fear, right? No more fear-based view of presidential power, which is to say the public has rejected Machiavelli, okay? Jack Goldsmith, who headed the Office of Legal Counsel for almost a year in the Bush administration, and during his tenure fought valiantly for the rule of law and upholding the rule of law within the executive branch, has written sort of a memoir of his time in government recently. And it's a brilliant account, which if you haven't read, it's called The Terra Presidency. I highly recommend it to you. In his account, he draws the conclusion that the president's approach to executive power ultimately failed, and it inevitably failed. Right? He says even if the war in Iraq had gone well, the president and the president's approach would have failed because the president's approach is focused too much on hard power, right? The powers mentioned in the text of the Constitution, and not on the president's soft power, the power of the bully pulpit. Right? The power to persuade people, to lead the nation in deliberation, to gain consent and consensus for the policies and programs that the president would then ultimately pursue. Right? This administration, says Professor Goldsmith, has rejected that approach to presidential power in favor of the unilateral approach, right, that does not engage in deliberation, right, that simply looks every 4 years for ratification. Right? And because that is contrary to our fundamental commitments to democracy, to civic republican values, it was bound to fail. Okay? That's our happy ending. I agree with Professor Goldsmith's argument, right, drawn from the work of historians and political scientists like Arthur Schlesinger, that at least in our polity, Machiavelli is wrong, right? That it is better for a president, looking at it just from the standpoint of presidential power, it is better for the president to take an accommodationist cooperative view rather than a unilateral and confrontational view. But I don't agree with the, I think, unduly optimistic claim that attempts to govern through the unilateral model are bound to fail. right? I don't think it's at all inevitable, right? For one thing, if you sort of remember back when I ticked off the list of our heroes, there was one missing from the list, Congress, right? Where has Congress been in all of this? Okay? Congress still doesn't get it, right? They capitulated on military commissions and domestic surveillance. They capitulated on the surge. They didn't agree to go along with the surge. They whined and complained and didn't like it, but didn't do anything to stop it either. They didn't provide any kind of a check. They've largely capitulated on the bailout, right? They made the bill for the bailout a lot longer. They put in more provisions. They authorized specifically more things for the executive branch to do. They put in a few modest measures for oversight, right? But basically gave the administration what it wanted. On the U.S. Attorney investigation, Congress has continued to pursue it, but has been stymied. Right? There was an important executive privilege decision that came out of the D.C. District Court recently. That'll get appealed. Eventually, someday, we'll get some of the information, and Bush will have long since left office, and the public's attention on the issue, I think, will long since have abated. Okay? Well, why doesn't Congress get it? Why doesn't Congress stand up as a check on the president? Madison's view, right, expressed in the Federalist and expressed in the structure of the Constitution, was that parchment barriers, right, legal constraints on power wouldn't be worth the parchment they were written on, right? That the way to constrain power was to structure it so that each institution would be ambition, and the ambition of each institution of government would counteract the ambitions of the others. Right? So the legislative institution would be ambitious. Its ambition would lead it to counteract the power ambitions of the executive branch. Okay? But Madison's account, which relies on institutional loyalty, doesn't take into account party loyalty. Okay? Members who want to get reelected, if they're from the president's own party, right, pursue their own ambition and self-interest by making sure the president is successful, by not doing anything that would embarrass the president. Because when the president looks bad, the party looks bad, and Congress changes hands, right? The in-party loses, okay? So that's important, but for the last 2 years, we've had Congress in hands of a different party from the president, and yet it still hasn't acted as much of a check on presidential power. Why not? Well, the executive branch has some institutional advantages, some very important institutional advantages. For one thing, the executive branch has all of the government's, or nearly all of the government's, expertise and knowledge, right? That resides in the agencies of the federal government, right? And they're under the control of the president. Okay? So the executive branch has that information and can, and over the last 8 years certainly has, manipulated that information, disclosed what's useful, withheld what isn't useful. Okay? So that's there. Sort of supplementing that, Congress itself is chronically campaigning, chronically distracted. Right? Members of the House of Representatives have to run for re-election every 2 years. They are constantly having fundraisers, having campaign events. They never stop running. And so they always have one foot in their home district campaigning and the other foot back in Washington to be engaged in policy deliberations. Right? But that's a serious disadvantage. Another factor that I think is sometimes undervalued is the other ambition of members of Congress. Their ambition isn't only to be powerful as members of Congress, right? I think it was 10 senators ran for president this time around, plus members of Congress, right? There's an old joke that when a senator looks in the mirror, he sees a future president, or she sees a future president, right? So what would you have said if you were an advisor to John McCain or Barack Obama in 2006 about what they should say about signing statements, about what they should say about presidential power, about executive privilege, right? Because they've got one eye on asserting those privileges in a couple of years, right? How effective can Congress be as a check on presidential power when so many of its members hope to one day hold the office of president, right? Or would be happy to give up their current job to serve in a president's cabinet, right? Lastly, I think members of Congress themselves realize this, right? Senator Levin was quoted in the New York Times magazine article this past week, and he was asked the question before the election, what should we do to make sure that the president observes checks and balances, observes the rule of law in the future? His answer was elect a Democrat, right? There is a lot we can do here in Congress. We can hold hearings, right? No, it was elect Barack Obama because he's a good guy and he'll do the right thing, okay? The court, right? The court, now there's a hero from my happy tale. But the Hamdi decision, the first in the line of decisions sort of checking presidential power, is interesting for when it was decided, right? After the case was argued, but before it was decided, we had the revelation of photographs from Abu Ghraib and the leak of the torture memo. Okay? It's speculative to think what the court would have said had those events not occurred, but it's hard to imagine they didn't have some effect on the way the court looked at the issues in that case and at the issues in the cases that came up later, right? And even if we set that aside, right, the most recent case, the Boumediene case, finally declares, right, that enemy combatants detained at Guantanamo Bay are entitled to petition for a writ of habeas corpus, right? And that's fine 6 years after the beginning of the War on Terror, but it doesn't tell us what rights are guaranteed under the Great Writ. Right? We haven't even begun to address that 6 years down the road. So what kind of constraint has the court really been on presidential power? Right? And the public, right? Oprah bounding onto stage, declaring that hope prevailed over fear. Well, maybe, but what would have happened if the war in Iraq had gone differently? If inspectors had found weapons of mass destruction loaded onto a cargo truck with a bill of lading for a certain cave in Tora Bora, right? What would have happened? Especially if we had then gone to that cave in Tora Bora and captured its occupant, right? Things might look very different now. So what to do, right? This is the shortest part of my talk, by the way, because first, what to do? Nothing that relies on Congress. Okay, right? Just not optimistic there. Nothing that relies on Congress. Perhaps some structural safeguards, right? If we look back sort of over grand sweep of American history, times when Congress has been able really effectively to stand up to the president, we've seen enactment of structural constraints, legal constraints on the exercise of presidential power, right? So after the Civil War, we had the Tenure in Office Act, the adoption of the Civil Service Commission, or Civil Service System, and those served as effective constraints on some abuses of presidential power, right, at least until the Tenure in Office Act was partly repudiated. But then we have the example of what happened after Watergate. Right? After Watergate, we have a reform wave sweep over Washington. Lots of legislation gets enacted. It does what it does, but here we are today, right? Wondering about the same conundrum, okay? Which leads me to what I think is really the only effective thing I can advise to all of you, and that is to watch and join, right? Join the American Constitution Society or the Federalist Society, whichever one you're oriented towards. Join the ACLU. Join whatever group it is that is congenial to your views, that watches the way power is exercised, because it's subject to abuse in any administration, even administrations headed by good people that we, or at least I, like. And so they perform a vital mission, right? It's the public ultimately that will stand as a check or not. Okay. So those are my thoughts about executive power. I'm happy to open it up for a discussion.
Has there been any occasion for the court to review the constitutionality of signing statements? Is that a likelihood?
I think it's not a likelihood, right? In fact, it is. It's hard for me to imagine the court having an occasion to review signing statements. For one thing, when a case gets to the court, they would be reviewing not a signing statement, but an action taken pursuant to a signing statement. For another thing, if you go back and read the individual signing statements, it's really hard to figure out what they say. You get their attitude, right? There's a lot of attitude in the signing statements, but there's not a lot of real legal direction, right? Plenty of sizzle, not much steak. So the most common formulation of signing statements is to say that X provision could raise serious constitutional problems under Y doctrine, the unitary executive theory, whatever it happens to be. And so I will direct the executive branch to understand this provision in a way that conforms with my Y power, unitary executive power, whatever it is. Okay, well, what was the constitutional problem in the first place? It's never identified. Why is that a constitutional problem in the first place? That's never identified. How will the statute be read differently from the way it seems to be written to accommodate it to the underlying constitutional theory? That's never set forth, right? So in order to even begin to contemplate a challenge, right, you need to have a party, right, which means there has to be some kind of direction out of the signing statements, and there just isn't. So the signing statements sort of as a body are emphatic, right, and seem to demand a response, but it's really hard to imagine what that legal response would be, right? Rhetorically, as a matter of political discourse and deliberation, right, I can imagine responses, and there have been lots of those. Right? But directly to any particular signing statement, it's really hard to figure out what to do with them except get mad and stomp, stuff like that.
Thank you.
Yep.
Along those lines, when a statement says that they'll take a certain provision as advisory, and then it's found that that particular action or that authorization or whatever was actually not executed, like it was not done, is there a way of bridging that causation gap? Because I know that Congress has been reported to, and the committee or the agency that did so said, well, we found that there's a signing statement saying we won't take it as law, we'll take it as advisory, and there was no execution of it, but we can't say whether there's a causation. If there was to be a causation, could you make an unconstitutional argument there?
Well, again, what needs to happen, assume there's never a signing statement. Right? What would happen then? What would happen then is what would happen if there is a signing statement, which is to say Congress could try to bring a lawsuit to compel whatever agency is supposed to issue a report to issue the report. Right? Would Congress have standing to assert that lawsuit? That's a whole other question in an area of constitutional law that remains dull. Right? So we won't get into that here. And so the signing statement doesn't add anything unless you understand signing statements to be part of the legislative history, right, which I suppose they are, right? But there's so little in the signing statement that it's hard to sort of credit it as any kind of interpretation of the law that's due deference. Maybe if we're sitting in a situation where Chevron deference would be appropriate and would be appropriately granted to the president, which are unresolved questions, right, then the courts ought to look at it from that standpoint. But the hypothetical that you raise wouldn't be that situation. So that would be a way that the signing statement's sort of correctness could get into court. And if its correctness rests upon a reading of the Constitution, then a rejection of the view expressed in the signing statement would necessarily be a rejection of the constitutional theory on which it's based. But even that wouldn't be directly a finding that the signing statement is unconstitutional, because the signing statement is just the ceremonial statement. Yep.
I heard the other day that President-elect Obama is planning to issue executive orders when he takes the office of the presidency that will overturn some of the executive orders that President Bush has issued. And do you think that that's the kind of tit-for-tat behavior that might continue into the future with future presidencies?
Well, if that's what President-elect, at the time will be President Obama, does, then it will be a continuation of the tit-for-tat that's been going on in presidencies leading up to this one, right? That's already the way it goes. So one that's certain to come up the first day will be the gag rule, right? The global gag rule, right? Which was issued first in the Reagan administration, right? It says that family planning grant recipients overseas cannot receive grants if they counsel on abortion, right? And so President Reagan first issued that as U.S. policy. President Clinton on his first day in office reversed that. President Bush on his first day in office reversed it back. President Obama on his first day in office, I imagine, I don't know, I haven't seen a lot of discussion of this, but I imagine will reverse it back again, right? So yes, the tit for tat will continue. It has continued. Now, there seems to be, I don't know, I haven't done a count, but there seems to be more activity in the area of unilateral executive action toward the end of the administration. And so more call for undoing at the beginning of the next administration. But in a lot of settings that gets complicated, right? Because if the rules involve APA procedures, right, that adds on a whole set of complexities as opposed to things that were done just straight by executive order under the president's constitutional or other statutory duties or powers. Yep. Do you know something about this?
We're just responding to the characterization of tit for tat. You could call these policy disagreements, and the gag rule's a nice example. I mean, President Reagan was actually reversing the policy of the Carter administration with respect to gag rules. President Clinton was reversing the Reagan policy with respect to gag rules, and President Bush was reversing the Clinton administration policy. So that's why we have elections. I mean, anybody who was having to choose between Barack Obama and John McCain would understand, if they thought about it, what the implications of electing one of those versus the other was with respect to a whole range of policies. And to the extent that presidents are acting within their constitutional authority, policy reversals or policy amendments are what we ought to anticipate when the presidency changes hands, or else why would we have elections that turn to some degree on policy disagreements? That's the parties disagree on certain important policies, and those get implemented more or less through the presidents of those parties when they're elected. Now, it's an entirely different matter, I think, and I think much more questionable. Let me give you another example of what I hope doesn't happen, but what might happen in the Obama administration, which would be to go systematically through the ranks of the line attorneys at the Department of Justice and try to fire everybody or find ways to remove everybody who was hired during the Bush administration. That would be a kind of tit for tat that I think would be dangerous to the integrity of the department. I think there are probably some people in the Justice Department who are there because they were hired improperly. However, I also think that if we're going to maintain some respect for the rule of law and the administration of justice, you've got to be very cautious, and I hope that the Obama group will right the ship on depoliticizing the process of hiring and firing in the Justice Department, which can't wait to begin until after you have purged, for political reasons, all the people that you don't like being there. So that's an example of a kind of potentially retaliatory policy that I think you could properly characterize that way and be concerned about. But when President Obama articulates and puts into effect a number of policy positions that differ from the Bush administration through the use of executive orders or other powers that are can be exercised by the president alone, I would think that you at least ought to think about whether those reversals aren't exactly what you would anticipate after you've held an election and elected the leader of one party versus another.
You implicated Congress in expanding executive power, and I'm wondering if you think part of what's going on is that Congress is in some ways trying to get access to information the executive has. In some ways, trading off, their checks for access to, secret briefings and things like that.
Sure, that's one of the things they've traded for, right? Is okay, we'll authorize your program if you brief us, right? Which, maybe at some point that can provide a check if members who receive the briefing then can do something about it, right? If you remember in the discussion of the warrantless wiretapping program, the administration let it be known that they had briefed the so-called Gang of Eight, right? 8 leading members of Congress on the issue, but the briefings were secret, right? And the members couldn't have staff present, right? They couldn't take notes, right? One member actually, right, Senator Rockefeller, sent a handwritten note to Dick Cheney complaining, right? But that was all he could do. He couldn't say anything on the floor, because if he did, he'd be disclosing what had been told to him in the secret briefing. So there have been some of those trades made, right? I'm not sure they're trades that really advance very much the cause of checks and balances and accommodation, so much as there's sort of scraps thrown to individual members of Congress.
Going to be a very broad question, but you were talking about the founders and how they had this ideal balance of powers where the ambitions of one chain would counterbalance the ambitions of the other, and this is how everything aligned. And then you suggested that this has kind of fallen apart, that the senators have personal ambitions, so that the Congress's ambition is kind of aligning with the executives. And some of your fixes were, well, the public should be accountable, and maybe short-term fixes such as congressional structural safeguards. Well, it seems to me that this implies a major constitutional misalignment with our current political system. So what has caused that misalignment, and how is there any comprehensive overhaul that may be possible besides the short-term structural safeguards that you propose?
Right. I don't have a comprehensive solution to the problem, right? What has caused it? I mean, I ticked off a few of the leading causes, right? One is that partisan loyalty trumps institutional loyalty, right? And other ambitions come into play that Madison and that our constitutional design don't really seem to contemplate, right? So you could think of structural fixes like a bar on members of Congress ever serving as president. I don't know, that's a great idea, right? But that would certainly address the problem. I think far too broadly to be anything I'd want to be associated with, just sort of off the top of my head, you could do that. But, I can't think of really good constitutional, broad, comprehensive fixes for the problem. I think the more realistic thing to think about is actually paying close attention to what it is that the government is doing, creating a sort of a public constituency for good government, right? I have no illusions that that's an easy thing to do, but as between that and coming up with some comprehensive systematic solution, it's more realistic.
Okay, thank you very much.